I am Soumaya Keynes. I am the Trade and Globalisation Editor for The Economist.
And I'm Chad Bown, a senior fellow at the Peterson Institute for International Economics. And actually, as you look around the room, I think half of the guests that we've had on the show are sitting at your tables. So,
yes, so this could be very dull.
Yeah.
Okie dokes. Before we begin, who are you? So hands up. Most important question, do you listen to Trade Talks? Hands up. Yeah,
Okay,
you can stay.
If your hand is not up, you should take out your phone right now.
Yeah.
And your
At the
neighbor
beginning,
will
Chad
show
would
you.
forcibly do that to
Yeah.
people, and I had to put a stop to that because people didn't like it. Okay, so how many of you are trade lawyers?
It's okay. Some of our best friends are lawyers.
Okay. How many of you are anti-dumping lawyers? Okay, this is going to be a very easy crowd.
Yeah, this is going to be good.
Okie dokes. Yeah. We'll explain why that is in a second. So
We have actually a few forms we'd like you to sign though, before we get started. So.
Yeah, so just to kind of, most of you listen to the podcast, which is great. So we thought we'd start off by sharing some things that we've learned from doing trade talks. And I can say this, as some of you are trade lawyers, not competition lawyers, but never start a podcast. Just don't do it. It will take up all your time. People hear the podcast, they think, oh, that sounds really easy. They're having a chat. It's terrible. Don't do it. Just listen to us. That's all you need to do. But the other thing to say is that, and I think you've heard a flavor of this so far in the day. We know that we got lucky, right? We know that people seem to really. Well, people in DC seem to really care about trade.
We heard from the last panel that apparently trade isn't a big thing across the whole country. It's mainly just us that cares about this.
We know that this moment is but fleeting, and that soon people will go back to normal and not care about trade at all. And at that point, we will bow out. Okay, so there are various things we could cover today. I think the title of this is semi-intentionally vague, tariffs. So we could tell you how well Brexit is going, super well, in case you were wondering. We could talk about US-China relations, also great. That chestnut that is the USMCA. We could talk about a juicy new appellate body ruling on a Russia-Ukraine dispute. Ooh. We could talk about countervailing duties against currency manipulators. Some fun, like late night, yes, someone was very keen on that. We're not going to talk about that. I'm very sorry. We're not going to talk about those things.
So no, what we are going to talk about is something actually much more exciting that I don't think was hugely on the program so far. We kind of skimmed it over. We know the DG was here this morning, and we're sorry to have missed that. But we're basically going to try to get into the demise of the WTO's appellate body. So have you had 6 sessions on that already today? No. Okay, good. So we're in sort of safe space.
Everyone knows though that it's struggling, right? That is.
Okay.
We're all on that.
It's not news. We didn't just break that to anybody. Okay. So the reason why we kind of did our quiz at the beginning is who you are. The last time we gave this little talk was back in November to the 20th Judiciary Conference of the Court of International Trade. And so that was a room about this size with about this many people in it. But they were all trade lawyers, and they were all anti-dumping trade lawyers.
Yeah, so Chad asked me beforehand whether we could title that talk, Why This Is All Your Fault. And I said no, and then he did it anyway. And that is why I am trying to handle the introduction this time. Yeah.
The room got a little bit quiet at that
You say a little bit. It was...
But you all are going to love this. Let me just... Entirely different crowd.
Yeah. So, right. So where are we? In case you've been living on another planet, I need reminding, the appellate body is not functioning. I don't think that the DG kind of broke the news that it was about to be reformed. And I'm sort of fairly skeptical that this is going to be fixed any time soon. My impression is that the US just doesn't have any major offensive cases that it wants to win. And so for the time being, at least, it doesn't sort of feel like it needs the appellate body in the short run. Now, that may be the case. It may not need the appellate body right this minute, but that's obviously not why it has sort of killed it. And so what we're going to do is we're going to kind of go through our understanding of some of the problems, taking a bit more of a kind of historical perspective than hopefully you have seen.
And so I'm looking around the room, and I recognize some folks that actually lived through this history. And so as we sort of talk through what the history, where the WTO appellate body came from, you should feel free to correct me if you were the one actually negotiating the Uruguay round and we get the history wrong. But basically, I think the way I think about it, at least, the 1980s is when all of this really started. So we had the GATT period that began after the Second World War, and it effectively kind of shepherded the trading system for 40 years or so. But by the 1980s, a number of problems had kind of come along. And yes, tariffs were low, or they were steadily declining over time, but there had been a creep of a different kind of protectionism, voluntary export restraints. And so this was, in the early 1990s, it was competition from Japan, it was automobiles, it was steel, it was semiconductors, it was a lot of different products. At its height, and I brought a copy of a paper here that we're writing to kind of write these things down, and so if I have to look up numbers in a moment, you'll forgive me. But at its height in the middle of the 1980s, about 12% of American imports were covered by some kind of voluntary export restraint, right? Which is basically the rest of the world being told that stop exporting so much into our market. And as an economist, this is not an arrangement that we particularly like because it can breed corruption, it can breed all sorts of anti-competitiveness concerns and sort of monopolistic kind of worries. But this was where we were in the 1980s. The United States this was its way of managing trade back then. We're seeing some of this, I think, again today, but this was a big problem in the 1980s. So we had these voluntary export restraints. We also had a problem of a lot of the American export interests, our key industries at the time, really weren't covered by the GATT. So services in particular, intellectual property rights, the IP-intensive industries, so you think of pharmaceuticals, Hollywood, media, that sorts of things, weren't really protected worldwide. And so there was big American frustration with the existing system at that stage. That combined with the fact that there really wasn't an effective system of dispute settlement. The dispute settlement system that existed under the GATT, any country could block the formation of panels or the decisions that got issued, really sort of led to a dysfunctional way of resolving disputes. So you put all these things together, and this was really led to the height of the Section 301 era the first time around. Now, there's a similar height or a different kind of height or low or something today with Section 301, but this is where it really reared its head in the 1980s. And what ultimately happened was the rest of the world disliked the combination of these things, and the WTO and the appellate body in particular sort of emerged as the grand compromise between the United States and the rest of the world. So the United States was willing to kind of give up Section 301, submit itself to binding dispute settlement when it came to trade matters, and in exchange for that, we also got services through the GATTs in, we got TRIPS, intellectual property rights protection in, and in exchange for that, the rest of the world got the United States acting a little bit less aggressively unilateral, as it was known at the time, right? And that's sort of the world that we inherited, or that started off anyway in 1995 when the WTO came around.
Yeah, so we have this 1995 agreement, WTO, that we all know and love, and as part of that, we have voluntary export restraints. They were supposed to be phased out. We do see a few of them. They don't go away entirely. I think some Mexican tomato exporters are aware, but that 12% of imports that they covered, that really does decline. Now, the idea was thinking about trade remedies and the kinds of defenses that would be able to be used under this new agreement. The idea was, guys, let's just not use these voluntary export restraint things. They create problems. Just let's shunt them to the side. But look, there are these other tools that you can use. We've got safeguards. We've got anti-dumping. We've got countervailing duties. And one of the things that was agreed was essentially supposed to make safeguards seem like a more attractive way of applying trade remedies. And so here I'm going to basically sort of, again, do a sort of Economist plug. So anti-dumping duties from an economist perspective are icky, and that is a technical term, and one that you will read in the pages of The Economist, I'm sure. They just don't, then they're not great, right? So safeguards, they make intuitive sense. There's a surge, you need some time to sort of adjust to that. They're temporary. Anti-dumping duties, they're kind of based on these funny principles that essentially they block something that a domestic company would be allowed to do. And so economists don't really like them, they don't really make sense. And here
Is this where I can put in my plug?
This is where you can put in your plug.
So you all, I think, are on my email distribution list, and I apologize for that, but you've been here all day, so you probably haven't seen the piece that I put out this morning. But it's basically, so this is the plug. So last week, the Trump administration decided to extend the steel and aluminum tariffs, right, to steel-using products, right? And so this was, at the end of the day, you add it all up. It's not that much trade. It's steel bumpers, it's aluminum bumpers, it's nails, things like that. It's only about $450 million worth of trade. Economists call this fear, though, the kind of thing that is happening here, cascading protection. So the steel and aluminum tariffs really raise the cost of inputs for the steel-using companies. The steel-using companies then come forward and say, hey, I can't compete with the Japanese or the European stuff either. I need tariffs, right? And so the Trump administration doled some out. But it's not that much when you add it all up. But when you look at the anti-dumping data, there is a lot there. And so you look at all of the derivative products that have come up for anti-dumping or CVD cases in the period since the steel and aluminum national security tariffs went on. And they do actually add up to something. It's about $5 billion worth of trade suddenly that are being covered there, right? So that's my plug for today.
Right, and the point there is that basically it looks like this is really being sort of driven by internal demand for protection rather than some sort of new anti-competitive practice that had suddenly emerged in the rest of the world, right? This is kind of how this law is set up to work. Okay, so we have this new system. We have the WTO, and essentially, I think there were certain expectations about how it would work, right? The expectation was that the US would use this new system to hold other countries to account. It wouldn't have to go off and kind of bully countries unilaterally. It could use this, technocratic system to secure its rights that it had negotiated, and that would be great. And
the other thing, and I should have pitched this too, because I'm sure some of you were in the room. During the negotiating of the Uruguay round, obviously keeping access to anti-dumping was very, very important, right, for the United States. Even though you may not be a trade lawyer or an anti-dumping lawyer, you know some, and for them this is the most important thing. And why is that? It's because Congress tells them it's the most important thing, right? Keeping access to anti-dumping. And so what they had done in the Uruguay round is they, as part of the new anti-dumping agreement, wrote this thing called Article 17.6 or something. And it's basically part of the WTO agreement that says, when it comes to anti-dumping, disputes over anti-dumping, you're supposed to just let countries do whatever their laws allow them to do. This notion of deference, right? And so the American negotiators felt like they were able to protect our ability to be able to continue to use anti-dumping, and we wouldn't really need to worry about it all that much when it came to facing litigation under the WTO. But of course, we were wrong.
Right. So what happened next was that other countries started using the system against the US, and one of the kind of main bones of contention was other countries were essentially accusing the US of using its trade remedies overzealously. Of 546 cases that went through the dispute settlement system, there were 141 brought against the US. That's slightly higher than its import share. Obviously, the US is a big importer, so one would expect it to be the subject of a lot of disputes, and it was slightly above that. And there were lots and lots of cases, and repeatedly these other countries won. Now, identifying wins and losses is tricky in the context of that system, because often the wins are partial, and so you can't really definitively say, yes, 100% we won this case or we lost this case. But there were enough decisions to leave some anti-dumping lawyers in DC pretty annoyed. And yeah, so another number, which is that more than half of the WTO disputes brought against the US were over its trade remedies. So this is a very heavily disputed area. Every single use of safeguard tariffs was challenged. So remember, the kind of the Uruguay round was there were changes that were supposed to make safeguard protection a little bit more attractive relative to what it had been before. And essentially after 2002, the US stopped using safeguards, kind of putting aside the Trump administration's use of them against washing machines and solar panels. Yeah, do you want to talk about zeroing?
Can I? Yeah, zeroing. Oh, we didn't ask this question at the beginning. The folks, so how many of you have heard of zeroing?
Oh yeah, sorry.
I'm looking at former ITC commissioners, and I know, yeah, okay. So well, then we don't really even need to explain what it is, right? Zeroing is this math challenging method of calculating anti-dumping duties. But basically what it is it just allows you to be more likely to find that there's evidence of dumping and to find a higher margin, right, in terms of the level of dumping, so a larger tariff can be imposed. Now, during the Uruguay round of negotiations, some countries wanted the United States to stop zeroing, and so they tried to negotiate for this. And the United States really didn't want to give it up, and so you look at the text, and it doesn't say anything about zeroing in there, right? It doesn't say that you can do it. It also doesn't say that you can't do it. And so when the Americans walked away, and when the rest of the world walked away, I think everybody thought, well, we won. Our side is represented by that text. Now, when it ultimately came to litigation, there started to be disputes over trade remedies, of course, and then ultimately there were disputes over zeroing. But does anybody know the answer to this question? Who was the first zeroing case against? And the answer isn't the United States. It was the EU. Does anybody remember who brought it? And it was over? So it was the India against the EU over bed linen. We need trade trivial pursuit. Does such a thing exist?
I think the market for that is in this room and no further. So that'll be a no.
Okay, we'll work on that. Right. So that was the first zeroing case, and the WTO ruled against that. And then a couple years later, the zeroing cases against the United States began. I think the first one was maybe Japan, and then one as part of the softwood lumber case with Canada. The Europeans brought them, and then basically, the next 15 years is just case after case on zeroing against the United States. It's the single most litigated issue at the WTO, is this massively minuscule technical thing that they do in the Commerce Department.
Yeah, so okay, we've now spent quite a lot of time talking about trade remedies, and this could be something to do with the fact that Chad has spent a lot of his career thinking and working on trade remedies. So as the non-trade remedies weirdo on the stage, so if you look through the official kind of USTR list of complaints about the appellate body, like why have we lost this system of binding dispute settlement? Why have we lost this kind of legalistic system that was supposed to replace the power-based system that there was before? You will see mention of trade remedies, but you'll see a bunch of other complaints as well, right? This is clearly not kind of the only. It's not all about zeroing cases, right? There are some other. It's
really all about zeroing, but
it's not all about zeroing cases. You will see a bunch of other concerns. So they will complain about essentially the way that the appellate body essentially interpreted the rules that the US had negotiated. We had Stephen Bown on Trade Talks recently, and he said, the problem wasn't with the rules that we negotiated. Basically those rules did us a fat lot of use. That's a very heavy paraphrase. Right, and so the concern was with the way that these judges then behaved, having been handed these rules. So one of the complaints was that they were just obsessed with maintaining consistency of their decisions over time, which meant that effectively precedent was set, and that's not okay, according to the agreement. One of the complaints is judicial overreach. So basically these judges sitting in Geneva getting a bit too big for their boots, making these decisions, seeing that governments are changing their laws in response to their decisions, and then essentially getting arrogant and kind of creating law when they really weren't supposed to be. Complaints about very, very long, unnecessarily long reports.
I think we could agree with those.
Right, making judgments on all sorts of things that they weren't asked to make judgments about. Making rulings saying, you know, well, this is a lovely case here, but I have this thought here, so I'm going to give you my view on this, which isn't necessarily relevant to the case. Making rulings by the text is ambiguous when, you know, the US might argue, probably if it's lost the case, that the appellate body should have just stood back and said, you know, this isn't for us. And you know, so there's one kind of, there are some sort of, you could attribute this to essentially complaints relating to personnel, right? It is possible that there were a few individuals operating in Geneva whose personalities clashed with the American way of doing things. And I would encourage everyone to go and read Paul Bluestein's excellent piece, which I'm sure Trade Talks is linked to about a bazillion times, detailing kind of the experience of you know, detailing some of those personality clashes that are clearly present. There's another kind of diagnosis of this, which is that, well, basically there was a bit of a disconnect between what the negotiators thought they were doing and what binding dispute settlement meant, right? So maybe you leave some of the text ambiguous. When you really want to do a deal, you really want to get it over the line, but it's just so difficult, but you really need to do it. So you say, you know what, we just won't mention zeroing. But you know, we're all friends, we'll work it out. Except when you then have the text and then people start making complaints and you effectively ask the appellate body, you ask the dispute settlement system to work it out for you, and then they start making decisions that you might not like those, right? And then the long run solution to that is like, okay, well, if you don't like the outcomes of those decisions, then just clarify what you meant, negotiate new rules. Except, as we all know, that is easier said than done when it comes to a 164 member strong organization. And then there's also a kind of a side question I have, which is, well, you know, from the US perspective, right? Supposing there's a body of cases that it's consistently losing over, and it feels like it didn't negotiate that interpretation of the rules, right? From the US perspective, why should they pay to get something that they never thought they'd negotiated away in the first place, right? There's a bit of a problem there. So I'm sure we've said multiple times on Trade Talks, everyone should just negotiate their way out of it so we can all be friends. But that is very difficult. Yeah.
And I think that ultimately is, I think, one of the underlying causes of the tragedy of the story, right? Is they're just, for as much as the complaint has fallen upon the appellate body and the dispute resolution function of the WTO is, you know, as we knew it, is disappearing. A lot of the fault of that is just because there was no way to legislate. There was no way to rewrite rules to deal with, you know, what may have just been political problems. This issue of zeroing is a really politically sensitive issue in the United States, and there may have been a way, right, to just kind of rewrite it to allow us to do it if this was so politically important to us without having to kill off the system. But it just didn't seem to be able to work itself out that way. Now, so all of this sort of discussion about where we have ended up in many respects may make it seem like we're defending at least some aspects of the Americans here in the Trump administration. And I think maybe to put that even more forcefully, when I look at the data on the use of trade remedies, not just the zeroing issue, but you know, since the WTO went into effect, when you look at the data, there's actually a sharp decline in American use of these things, right? So by 2013, we're living in a world in which the United States, we actually have very, very low tariffs. You know, that are averaging 3%. We've got free trade agreements with Canada, Mexico, Korea, a number of big countries that are making effectively those tariffs even lower. You know, it's about as open as the United States has ever been historically in terms of, you know, it could be that this dispute settlement thing actually did constrain American use of trade remedies. It's also plausible that it may have just constrained them a little bit too much. And that's partially what has sort of contributed to this reversal, right? We can ask ourselves, would the Trump administration found it necessary to do the Section 232 actions on steel and aluminum had they instead had access to a safeguard mechanism, right? Or the China tariffs if there was something else out there. Well, maybe China not, but other sorts of protection if the WTO and the appellate body in the American view hadn't been so heavy-handed toward trade remedies, right? Now, so there's something there to support that in the data. Don't quote me too heavily on that, especially as an economist. But I think there is an argument that you need to have some access to these kinds of instruments to make sure that you keep overall levels of openness and cooperation feasible, and there's a sense in which that may have been pushed a little bit too far. Now, but to talk a little bit about some of the procedural challenges, right, that are now going through, and we will hopefully have time at the end to talk about ways in which at least the rest of the world is temporarily dealing with the problem of the appellate body. In some instances, some of these procedural complaints probably are legitimate. There's other countries out there that share the American concerns. I talk with, Canadian lawyers that can very much understand the American concerns about some of the judicial overreach questions, the violation of the 90-day rule, that these decisions are supposed to be getting out more quickly, and the appellate body just seems to be holding on to these things forever and not really doing their job. Some of the decisions on kind of the legal stuff they might agree with as well. One of the very important issues, it's not an anti-dumping, it's a countervailing duty issue, right? On public body, the concern of, maybe these Chinese state-owned enterprises that we're worried about, maybe they are actually giving subsidies to downstream companies through really cheap inputs that they might be providing, right? I think there's some common feeling from other trading partners as well that the Americans aren't off on their own on those particular issues. So there is, I think, some areas where there would be other countries in agreement. I guess the concern I think that I have, and maybe Soumaya might share as well, is the approach that's currently being taken, where it just doesn't seem as if there's any, at least on the American side, interest in coming to a potential solution or resolution to the underlying problems and how to fix it. And so now we're at the point where we've recognized there's a problem. The rest of the world seems perhaps ready to engage on some of the substantive issues. And yet coming out of Washington, it's essentially, at the moment at least, radio silence.
I think, another kind of pushback to the idea that this is just, the US has pushed too far. There was a problem with the kind of political economy is, well, if you look at the industries that are appealing for protection from these anti-dumping duties, there are a few that are very, very well represented, and that there are a few key players within the Trump administration who represented them. And so maybe this is, it is inevitable that at some point the likes of Robert Lighthizer were going to, get to the helm of USTR and axe this thing that he never really liked in the first place. Maybe the kind of the political and sustainability things was, we couldn't prevent someone like him with sort of such irritated views towards the appellate body from essentially getting the power over its existence.
And I think let me also interject there. One other, in our conversations with people around the world about this, they're also a bit flummoxed with the current administration's position on this and the feeling that we didn't, I don't think, articulated this, but there's this also sort of subtle underlying concern that sometimes is raised by the American legal community that maybe the WTO has become too European in its approach to law, right? The Europeans are sort of treating it like the European Court of Justice, and that's just not the way we do things in the United States. Right? And so there's this difference between treating the sort of the WTO as a contract versus, sort of a European approach. And this is kind of a very philosophical legal argument, and also I think one that the rest of the world struggles with, because when they look at the cases that are getting litigated in Geneva, frequently the two sides of the cases, it may be, the USTR may be on one side and some other country on the other, but it's frequently two American law firms that are battling itself out in Geneva. right? And so they look at this and they say, how can you possibly be having a philosophical argument about the European approach to law and the American approach to law when it's two Washington, D.C. law firms that are litigating it there in the court too?
This point didn't go down very well.
Yeah,
The point of international trade. Just
the
FYI,
other
they didn't like that very much.
Some of my best friends are lawyers, I promise. Yeah.
Yeah, I think so from the rest of the world, it kind of the risk is that that basically they see what the US is doing, and it looks like a case of kind of American exceptionalism. It looks like the Americans are happy to have a rule book when it kind of works in their favor, but look at these cases, and actually they've decided to walk away. And basically say, no, we want to essentially bully other countries into submission. Doesn't look great from other perspectives. And the US approach of kind of saying, nope, we don't like it, and other countries coming forwards and trying to come up with solutions, and the US not engaging and saying, well, no, we want these kinds of solutions. The US just saying, nope, we don't like them. That I think has kind of bred a certain resentment elsewhere, and really raised questions about whether the US is really kind of making these arguments in good faith, or whether they just want to kill it and not have a solution at all. And then, and I should say on this issue of precedent, this is one of the American complaints that the US, the appellate body is obsessive about precedent. Well, the US has in the past been quite happy to file what it calls systemic cases, right? You can't really, it doesn't really make any sense unless you're trying to set some kind of precedent. So again, kind of, we're only really upset when we lose cases, and we're happy to take the wins.
I think they'd be pretty happy about a precedent case on public body that was along the lines of how the Commerce Department sees it, for example. Yeah.
Exactly. So we have 30 minutes left, and I guess some of you have been whispering angrily, so I want to give you a kind of opportunity to tell us we're all completely wrong. But yeah, so the final, I guess this is kind of a bit weedsy point, is that perhaps the problems of the appellate body were, there was actually something with the way that the rules were written way back then, right? At the moment, you could argue that essentially, collectively, the WTO membership overburdened the appellate body. They asked it to do too much, and then when it did the things that were asked of it, inevitably that was going to create problems. If you think that the Boeing and Airbus dispute, if you really think that needs to have been a negotiated settlement, then why try and litigate this case for years and years and years at this body? If there are a bunch of issues where, well, if you really thought it was ambiguous, then why did you try and litigate? Why didn't you give the appellate body some way of saying, you know what, we don't have enough facts, right? One of the accusations is that the appellate body has been going out and fact-finding itself, which it's not supposed to do. This relates to the 17.6 provision that was agreed. Well, you need to give the appellate body some way of saying, you know what, we're going to push this back down to the panel. The Supreme Court in the US, they don't have to hear every single case that people try and push up to them. They can push stuff back down. There isn't that mechanism at the appellate body. So maybe there are some, they sound like really weedsy, kind of boring, surely that can't be the problem. But maybe if some of those mechanisms had been put in, a bit less of this pressure would have built up, and we wouldn't be where we are today.
So I think, just to conclude, maybe I'll say two more things. One, I think, is it took the rest of the world a while to understand the severity of the issue, in part because there was so much other stuff going on with the Trump administration's trade policy that it kind of didn't know how to interpret this, right? But I think a lot of the issues, certainly the substantive issues, and especially when it comes to the trade remedy stuff, the tactics may be new with the Trump administration, but the concerns really are not, right? They were raised in the Obama administration. They were raised in the Bush administration, and some of them were raised, back at the very beginning of the WTO. Some of these concerns. So I think the Trump administration didn't do itself any favors by not really kind of clarifying what the issues were that were most important for it on this particular track. So where are we now? Well, now we don't have a functioning appellate body. There is a group of 16, 17 WTO members. So the EU has sort of an interim agreement with Canada. They've got one with Norway. And they announced last week in Davos with a group of 16 other WTO members that they're going to try to plurilateralize that to basically any countries that want to come forward as a temporary workaround, this under Article 25 or something like that, sort of an interim appellate body that would handle concerns until the full-on system gets resolved. But I think the main concern is that there's really no sense in which, on the American side, there's going to be engagement to fix some of these underlying problems. So what may very well be an interim solution that's being put forward by the Europeans and China and a couple of other members could very well be the solution that lives with us for a long time for those countries. And then for the United States, WTO dispute settlement. It's really unclear what that's going to mean and what that's going to be looking like and what all relevant is that's going to be. So,
Questions?
Questions. Or you can just, this is now where you can get mad at and tell us how wrong we were all along.
Chad, so first of all, your socks are on brand.
He didn't wear the tie. I'm sorry, guys. He didn't get the tie. Next time.
Next time. Yeah.
I listened to all your podcasts. The Stephen Bown interview was one for the history books. So next year, Trade Promotion Authority expires. And so I wanted to see if maybe you could share some thoughts on what you think the trade landscape looks like. There's this whole conservative argument that there's a resurgence in non-delegation doctrine, right? And so maybe this is Congress re-exerting its power back on the executive. So I'd love to kind of hear your thoughts, and then what the implications are for some of the existing trade deals, and especially with regard to U.S.-China.
Well, I'm very excited to hear that Bernie Sanders would renegotiate the USMCA immediately. Who else is excited for that? I might cry if that happens. Yeah. Well, I mean, so it's got to depend on who.
Yeah.
On who wins, right?
Yeah. So I think, but this raises a really good question. So I know there's big debates happening in the United States right now. Also, when we talk to folks around the world, there's always also very much a sense of we'll see what happens in November.
The president wins, though, so just kind of.
Yeah. Well, I mean, I think that's where countries really are, and they kind of haven't fully, and they're gaming out now what their strategies are. I mean, I think from the U.S. context, what would it mean? I think it depends on what Congress looks like and if what Senate looks like. So yes, it could go any way. And the one thing I've learned with President Trump is never try to predict anything.
So one thing that was super interesting, so as part of the British election, some of the British civil service notes of meetings that they'd had with USTR got leaked, which was great for me because I could get information on what USTR was thinking.
This is what she does on weekends.
Yeah, literally a weekend. And one thing, and so the issue of TPA came up in those meetings, several hundred pages. Right. And my recollection is that USTR didn't seem to be that sort of concerned. Even I mean, you should go back and look, but my fuzzy recollection is that even if they didn't get TPA, they didn't seem to be that worried. Now, that could be just because there would be so much support. They think there would be so much support for a UK FTA in Congress. I have also seen the point made that TPA is supposed to basically allow you a kind of straightforward up-down thing in Congress, but in a world in which the Democrats want their share of concessions after USTR has already gone off and agreed something and the thing has even been signed. What's the point if they're going to try and negotiate again anyway, right? There's exactly, right? And so if that process is just going to happen again next time, I mean, I guess it also just depends on the balance of
But I think that's a charitable interpretation of negotiations. The Trump administration might go to the UK and say, well, under Section 301, we're just going to raise all of our tariffs toward you to 100%, and so then you cut all your tariffs toward us, and we'll just lower them down to what they are normally, and then we don't have to go to Congress, so we don't need TPA anyway. So sounds sort of like Japan, and we'll see. Other questions? Doesn't have to be about this. Things that you would disagree with us on Trade Talks, other things too. Feel free to, this is your chance to really let us have it, please.
Thank you. Steve Landy, Manchester Trade. Let me make a trivia question for you and then a real question. My first memory in trade policy, which was more than 50 years ago, I'm even older than Alan Wolf in trade policy, was the Kennedy round. And when the Kennedy round was over, Senator Russell Long, who was the power in those days, returned the U.S. Kennedy round agreement on a roll of toilet paper, which he chose the dumping provision. And we made some change in the dumping provision that would have impacted the chemical industry, which came from Louisiana. If anyone knows what that change was, I would appreciate it. But do look it up in history, because it's a great way to begin your stories about dumping, the return of the provision. The question that I basically have for you is, my own personal prediction is that the first thing, if we get a moderate Democrat after Iowa to run in the race, will be that he will announce that we are going to begin to join the TPP. And the TPP will then become the major negotiating instrument with China. Do you think that's possible? And what would be your reaction to that? And so on.
So my kind of problem with the US joining TPP is rules of origin in autos. If you think that that was basically the one substantive change that the USMCA made to NAFTA, I mean, there were others, but if you think that that was the kind of the one that caused one of the more substantive changes, it went in the other direction, right? They went tighter, and TPP obviously went looser. So I don't know, after everything that we've been through together, if the US is going to turn around and say, oh, actually, we want those looser ones, I don't know what Congress is going to say about that. And then I don't know, I don't know how, like my brain kind of hurts thinking about how marrying those two sets of rules of origin would work, given how much it would just kind of undermine everything that that the US has just negotiated.
It's okay, you can say we. I hate rules of origin, but you dig it, so.
So
there was a question over here, sorry. Dan.
Dan Pearson, Americans for Prosperity. I'm inferring from what you're saying that you expect the appellate body is likely to remain dormant through the rest of this year. But there is another possibility that I would bounce off you. My view is that the trade remedy attorneys currently running U.S. trade policy are actually quite intelligent people. I know a number of them, okay. And
I don't think we said that they aren't.
No. But I mean, it's okay. They're intelligent enough. Look, they understand they won't be in office forever. So they have some months in which to consider whether they want to go ahead and try to actually reform the appellate body. Keep in mind that many of them worked for industries such as steel, and I know that that industry is represented in this room, that really would like some change in appellate body procedures going forward, such that they could go back to using zeroing or other measures, and the appellate body actually would sustain that. The United States right now has quite a bit of leverage on this issue, diminishing, I think, as time goes on and the workaround arrangements are made. But the United States has leverage, if it wishes, to actually try to bring about reforms. Do you think that's a possibility in the remaining months of 2020?
I think it's possible. I just haven't seen a hint that that they would engage on that. But yeah, no, I agree, and they are incredibly knowledgeable about exactly how the system works. And if they wanted to, I think they could use this as a way to rewrite things in a way that would be more amenable to those certain interests. But, you know, if you take Ambassador Lighthizer at his word, what he said publicly is, you know, he likes the old GATT system. And so I think it's entirely plausible that, you know, not having an appellate body is something that they'd be happy with as well.
Yeah, I'm hopeful, but not. I don't think it's going to happen. I'm so sorry.
So we're going to wrap that up here. Thanks to Chad and Soumaya.